All right, there we are. All right, we have 77 participants. Welcome to Accessing Opioid Settlement Funding for Harm Reduction Programs. My name is Mary Silla. I'm the Director of Overdose Prevention Policy and Strategy for the National Harm Reduction Coalition. As I said before already, we'll be taking questions through the Q&A, so please use that function if you have a question. We are recording this session. That gets asked every single time. We're recording this session, so it will be available publicly after the presentation. And believe me, you're going to learn a lot of stuff that you think, wow, I wish I could share that with people. So that will be a great opportunity. Christine will present for about 45 minutes and then take questions. We have an hour and a half. And so I'm hoping everybody who has questions will get those questions answered. And again, you can come off mute if you want to during that portion, if you want to have a dialogue with Christine. So now the formal introduction part. I am so pleased and fortunate to introduce Christine Minhee today. Christine is the founder of the Opioid Settlement Tracker.com, where, as you'll hear more about today, she single-handedly has tracked the opioid settlement litigation in the US and now is tracking the state's publicly reported spending of the settlement funds to see if they will indeed be spent to bolster the public health response to drug use. She's a graduate of the University of Washington School of Law, where she launched this watchdog project as a Soros Justice Fellow, and she's now a visiting scholar there. And she holds an undergraduate degree from Stanford. Now, over the course of my career, I've worked with a lot of different lawyers. I've worked with lawyers who were nice. I've worked with lawyers whom I respected, and then those I thought were really making a meaningful change in the world for a better, but usually not all in one person. And Christine is an exception to that. She's exceptionally pleasant, brilliant, and really creating change with the information that she's gathering and sharing. She's working outside the box. She's not working in a big law firm. She's taken this project that she created, her brainchild, and really, as you'll see, it's unlike anything else in terms of allowing people who are doing harm reduction work and trying to improve the lives of people who use drugs with these opioid litigation funds and getting the information out there. So I really think it's remarkable, and I'm grateful to her for the work. And I'm also just grateful to her that she was willing to show up and be on this webinar with us today. So with that, I'm going to turn it over to Christine Minhee.
That is by far the best introduction, the kindest, most generous introduction I've ever heard just of anybody, but it's for me. Thank you, Mary. I'm properly emotional now, but I feel like, you know, that matches the kind of the gravitas of what we're talking about, right? You know, I have the plastic skeleton in the background from Costco. You know, it's visual stimulus for my drug policy webinars of the past. But this is a serious topic, and we're in the room with a bunch of heavy hitters today. We're going to be talking about very important things. I'm beyond excited to talk about opioid settlements with you guys. I have a slide deck that I'm going to show you in a bit, but thank you so much, Mary. Thank you so much to the National Harm Reduction Coalition for having me. It is such a pleasure. And hello from Seattle, where it is semi-cloudy, kind of hazy. I don't know if you can see the reflection from my cheeks, but it's pretty hazy today. Here we go. So we're going to screen share. All right. So as Mary said, I do run opioidsettlementtracker.com. Did you know that it's a one-woman show? Now you know. Now you know. It is. So opioidsettlementtracker.com. It's actually a Squarespace subscription as well. So shout out to Squarespace. As Mary mentioned, I started this as a Soros Justice Fellow, and since then I've managed to be able to convert some of my work to an advocacy consultancy. So now I get to do this all the time, and it's such a pleasure because the very thing I like to talk about most is also what I'm going to be talking about today. The title of these office hours, you know, accessing opioid settlement funding for harm reduction programs, pretty straightforward. It affords us a type of organization as well, because I'm thinking about this in two parts. We're going to take it in turn. First, we're going to talk about opioid settlement funding. Like, what is it? Just purely as a level setting exercise. When we're talking about opioid settlements, what are we talking about? What's the status on that? Then we're going to be talking about accessing them for harm reduction programs, which is the heart of our office hours today. But when we think about opioid settlement funding, we're going to break it down to two. First, it's going to be an update on opioid settlements in general. Then we're going to do the update on the state's publicly reported opioid settlement spending plans. The TLDR, the too long didn't read, is that almost all states have published plans. We're going to get into some of the higher points. Part two, accessing for harm reduction programs. This is where I'm going to give you the lay of the land of expenditures, what states are able to spend these monies on. There's a document called Exhibit E. If you've never heard of it, fine. We're going to go through it. It's going to be a level setting exercise as well. We're also going to talk about how to figure out who to hound. I don't know if you guys can tell, but I've been trying to position myself as the unofficial consigliere to harm reduction activists nationwide, looking to spend opioid settlement dollars to move the needle on public health and generally bend the arc of humanity towards justice. So as your consigliere, who to hound, right, is an important thing. And then also how to avoid being hustled. We're going to go through the most common excuses that some of my harm reduction activist colleagues get. And built into this is an exercise related to how to use citations from the settlement documents as receipts, because it's always great to come equipped with rebuttal evidence if you are too often told that nobody is doing it your way. We're going to show them. So this is the full slate of topics we're going to be talking about. Naturally, we'll kick it off with an update on opioid settlements. So the update, I'll kick it off with a pro tip, right? If you guys want the bird's eye view, so the aerial shot of states' major opioid settlements, go to opioidsettlementtracker.com. The homepage looks like this. You want to go to the Global Settlement Tracker tab, where you'll access a spreadsheet called States Opioid Settlement Statuses. And you could also access it here. This spreadsheet, and I'll show you a screenshot in a bit. The spreadsheet is a 50-state survey of settlements reached with the most widely known. So like the biggest household names, manufacturers, distributors, and retailers being pharmacies. It looks like this. It's kind of a crazy spreadsheet. And it's color coded because, I wanted to show which settlement amounts were reached as a result of blanket offers made nationally, even to non-litigating states and localities. So if a city or county didn't sue, but they're partaking in a settlement, that's typically what, the green and red stuff, right? Blue, I hold out as separate and apart settlement amounts reached with actual trial dates docketed on a calendar. So for the legal nerds in the room, green and red, we can think of, the threat of settlement as proximately causing, the threat of trial proximately causing settlement, right? With blue amounts, we could think of, actual trial as cause and fact of settlement. That means nothing to you. That is totally fine. Because this whole spreadsheet, the overarching goal is to contextualize the global opioid settlement against the others. Because when we're talking about a global opioid settlement, right? So this is a global settlement tracker. It's kind of like the meta name, but when you're reading opioid settlement articles, or if you're reading things about how states or localities are planning to spend the funds, and you see something called a global opioid settlement, it's a specific thing, national or global opioid settlement. It was finalized in this year. The offer was made in July last year. It's a very specific thing. It's a $26 billion offer to settle, made by 4 defendant offers, okay? So the big 3 distributors, McKesson, AmerisourceBergen, and Cardinal Health, and the manufacturer Johnson & Johnson. And this offer is made to 2 sets of plaintiffs. The AGs, whose opioid cases were proceeding in the state court system, and the cities and counties whose cases, for the most part, have been lassoed together into the federal multi-district litigation based out of Cleveland. And that's kind of where things get confusing, I think, because it feels like a category error, right? Like state AGs proceeding in state court, fine. The localities, their cases have been lassoed into federal court and this federal MDL. That's where things kind of get confusing for folks. Suffice it to say, just for our purposes, this offer purports it intended to, and it does, settle both lines of cases from both sets of plaintiffs. And that's why it's called global or national, because it resolves both sets of plaintiffs, but it's not global or national in that it just solves everything. It only resolves litigation against the above named defendants only. Translation, This $26 billion global offer doesn't resolve Purdue, doesn't resolve Mountain Crop. It just, that sits off to the side, okay? And it's also why the pharmacies are still in litigation, because the pharmacies are not represented in this defendant offer list. Do we have global peace? Okay, because these big offers are made by these corporate defendants with the goal of achieving global peace, to not have to deal with a ton of litigation in perpetuity, right? So do we have global peace? I'm just going to throw this up here. This is the full list of original non-participants, partially participating states, and one state that is technically ineligible to participate due to past settlements. I'll show you guys a dorky little citation related to West Virginia after that some of you guys might get a kick out of. But in any case, the details are up here, and also on my site under the Global Settlement Tracker tab. I'm just mentioning the type of patchwork of states that are and are not participating, because it does resemble the level of participation involved in the Big Tobacco Master Settlement Agreement. So when we're talking about opioid settlements, when people talk about the opioid litigation, typically there's an obligatory Big Tobacco nod. So I'm going to do that now. The Big Tobacco MSA refers to the Big Tobacco Master Settlement Agreement, finalized, reached 1998. Depending on which valuation you're relying upon, it's $206 to $246 billion. Here, the defendant offerers were the four majors. So the four biggest tobacco manufacturers, okay, keep that in mind, just manufacturers. And the plaintiffs here were the 46 states AGs. We have 46 state AGs participating in our global opioid deal. We have 46 state AGs participating in our Big Tobacco MSA, and both, threaten public health litigation that relates to public health. But as far as the similarities go, that kind of where it approaches its end, because if you really think about it, consider the endless amount of permutations that are unlocked by adding another set of plaintiffs, right? And two other sets of defendants. In the Big Tobacco context, it was really the manufacturers that were the corporate bad actors, or considered the corporate bad actors and major defendants. Here, we have manufacturers, distributors, and retailers. In the Big Tobacco litigation, just the state AGs were doing the major push through a few cities and counties, but that doesn't really matter because they were so negligible. Here in the opioid litigation, we have two sets of plaintiffs. So and then you multiply that by the, however many variations of state public nuisance laws there are, and you get this endless permutation of results. The opioid litigation is a lot more complicated than the Big Tobacco litigation, primarily because of the fact that for a while, the biggest drama existed not between plaintiffs and defendants, but between the plaintiffs themselves. Back when oh, by the way, if you want to learn more about Big Tobacco and how it relates to the opioid crisis and everything, there is an article that I wrote as a law student. A fun fact I will note is that the S. Calandrillo is a Steve Calandrillo, my favorite professor in law school. He's actually Kim Kardashian's favorite Barbary instructor. Barbary is a law prep course. Was the strangest thing. This is a complete aside. It was on Kim Kardashian's Instagram stories. Don't ask me why. And I see my co-author. She's shouting out to my co-author on her Instagram stories. And it was by far one of the most confusing moments of my career because I didn't know what to do. It's like, do I message her? Do I message her PR team? It's like, yeah, I need a KKW beauty stick. Moving on. But in any case, if you guys want more about Big Tobacco, it's all in there. But as I mentioned, for a long time, the biggest drama was between plaintiffs and plaintiffs. So when I first started doing presentations on the opioid litigation, I used to start with this slide. I paraphrased the prologue to Romeo and Juliet to kind of phrase the cities and counties in the states as the Capulets and the Montagues. So I'm shouting out to my English major nerds here too. So we do have two lines of litigation in the opioid litigation. Cases lodged by state AGs, cases lodged by localities. That's why the global deal is called global, because it resolves both sets of litigation. In this fair webinar where we lay our scene, we cannot, extract the war on drugs from everything we're talking about today. That forms a backdrop of everything, and that forms a backdrop and it forms the impetus of why harm reduction is just so absolutely necessary. And where civil litigation makes civil hands unclean. Typically, when we're talking about civil litigation, making civil hands clean, we're talking about attorney's fees. But given my role and given my lane, I have a vested interest in not discussing that too hard. So we're going to move on. So that was an update on opioid settlements. We're going to get into, how are these settlements going to trickle down, so to speak? What are the plans that detail how they will be spent? Okay, so an update on states' opioid settlement spending plans. We're going to kick off this section with a bit of a pro tip as well. Here's a homepage of my site. If you guys want links to states controlling documents, you go to the settlement spending tab. There you can access a spreadsheet called States Opioid Settlement Allocation Plans. You can also click here. And this too is a 50-state survey, but here it's of states' publicly reported opioid settlement spending plans, which take one of three formats, okay? They're either state subdivision agreements, like North Carolina's memorandum of agreement, which is typically considered the exemplar, or the kind of at least the hall monitor of what states should be doing or what they ought to aspire to. There are also statutory trusts. Okay, these are bills to create special buckets to hold separate opioid settlement money separate and apart from the general coffers. Our example comes out of Massachusetts today. Then we have allocation statutes. These are, bills that hopefully turn to statutes that speak to allocation, state local allocation of a state's entitled slice of this $26 billion pie, for instance. How much of this slice can the state keep for itself? How much does it have to pass down to the localities? Allocation statutes discuss that. And our example today comes out of Indiana. My site, just FYI, a little plug, it tracks pending legislation as well. So for those of you who have been curious or know that the Plaintiffs' Executives Committee's website exists and are curious to how my site differs, my site tracks pending legislation. So you could consider my spreadsheet the superset of what the PEC has, and that may or may not be a humble brag. But moving on to settlement spending plans, I want to just go over some of the high points. I mentioned this earlier, that almost all states' plans are publicly available. That is absolutely the case. The wait and see approach I'm taking with DC and Hawaii, primarily because I've heard rumors, but as far as things that are Googleable using my skill set, I have yet to see something. And frankly, folks from DC and Hawaii, please send me any info you have, would be dying to know. Related to states' plans as a whole, there is a massive, massive range of breadth and depth when it comes to what these plans cover. Almost all of them address spending priorities, because it would be insane if they didn't. Many address state local allocation, right? So how much can be kept by a state? How much can sit with the fund? How much can go to the localities? If they don't address it, there's a default allocation that they have to follow. Not important for our purposes today, but moving on. And some of these plans just simply work to create a fund, right? So some of these plans are really just a statutory trust bill. So there's a big range of how much effort and time states have invested in these plans. But all of them, as a fact, just as a rule, are shaped by the requirements set forth in the distributor and Janssen settlement agreement documents. Okay, so that $26 billion deal I mentioned, the big global one, the biggest one on the table. There are settlement documents that describe, the details of that settlement agreement, the distributor and Janssen settlement agreements. Janssen is Johnson & Johnson, okay? These agreements, if you read through them, and I'll provide the link in a second, if you read through the actual settlement agreements for this $26 billion deal, the documents anticipate states' plan taking one of three formats, and that's why we see state subdivision agreements, allocation statutes, or statutory trusts. This is the reason why states are articulating their ambitions for settlement spending via these formats. The citation for that is here for those interested in receipts. And just by the way, I'm going to be dropping citations left and right, just because I want to use our time, maximize our time, and just hand off as much information as I possibly can. But when I'm citing to something or when I'm referencing a citation, know that I'm referring to the distributor settlement agreement documents, which can be found here. I made a bit.ly link too. So there you go. If you guys are interested in following along, go ahead, check out bit.ly distrib docs. Little fun fact, you might have noticed the asterisk up here. DC is considered a state according to these settlement agreement documents. But hilariously, and also logically, if you think about their litigation history, West Virginia is not. Okay, so West Virginia is not even not participating in this global deal. They're technically ineligible. So ineligible that the settlement agreements exclude West Virginia from its definition of a state and include DC, which is why I'm so curious about DC's plan. But the biggest requirement from these agreements that we have to go over today, because it is by far the most important, 70% of settlement funds must be spent on a thing called future opioid remediation. Okay. To go over this, I'm going to bring up an example. So as part of my job, I read every single Google alert containing the words opioid and settlement. This is why there's so much coffee in my apartment. So when I read through these Google alerts, I'm often trawling through local reporting on city council like agenda topics, and I'm trawling through like county meeting minutes and things like that. And sometimes I find coverage from meetings like this, and I noticed this, I read this, and I thought they almost got it right, but they did get it wrong. This misstates the requirements under these agreements. I'm not going to expect you guys to know how to correct it, but given my late English major and English teacher fantasies, I'm going to do this like, these slides where your English professors or your English teachers would say like, this is the incorrect version. This is the correct version. Well, this is the corrected version. It isn't true that 70% of funds must be used, 70% of all settlement funds must be used for opioid use treatment, whatever. It's that 70% must be used for future opioid prevention and treatment. And not 30% can be used for any government purpose, but 15, it's capped at 15. These next couple of slides, all right, it's pretty arduous because I'm a linguistic person. I'm going to throw a lot of numbers up here, so I'm revealing myself here. But I find these next couple of slides arduous. So if you do too, you're not alone. But we're going to go through them because it's tremendously important to trace at least once through the reasoning that allows us to reach this conclusion. The conclusion being that states have to spend 70% of their opioid settlement funds on future opioid remediation. And what future opioid remediation is, obviously, we're going to be defining that as well. So to kick things off, I made a diagram. Okay, circles. This represents 70%, roughly. 70% of funds, as I said, must be spent on future opioid remediation. These are the citations that go towards that point. The big thing to take away from this fact is that as long as a state hits that threshold, they can divvy up settlement funds however they want between the states, the localities, and a special fund to hold money separate and apart, if any. The allocation can be kind of whatever, provided that the 70% future opioid remediation threshold is met. Which kind of begs a question, like, what is opioid remediation? If you're guessing that it's like treatment and prevention and the stuff that'll actually abate the crisis, you're generally right. It's kind of the gist with some nuance. The nuance being this, okay? So in the settlement agreements, you'll find language like this, in no event may less than 85% of funds be spent on opioid remediation. Opioid remediation is defined the way that we kind of haphazardly defined it, like, it's all the stuff that'll abate all the things that'll abate all the things. But it also includes reimbursement for past abatement expenditures and also reasonably related administrative expenses, okay? Which is to say, okay, so why am I talking about this 85% thing? 85% minus 70% for future opioid remediation. This means that there's a 15% max. There's a cap on how much money states can spend on reimbursement for past expenditures and administrative expenses. And it's 15%, okay? So a state can't say, hey, yeah, we're spending 70% of our monies on future opioid remediation if they're just reimbursing themselves or past things and also administrative expenses. That isn't really a meaningful that isn't really a meaningful spend, just philosophically speaking. So this is why this future opioid remediation thing really matters. Future opioid remediation is opioid remediation minus the reimbursement and admin expenses. It's the stuff that is prospective, future orienting, and will move the needle going forward, okay? And that, so 70% for future opioid remediation. It's the yolk, okay? So I know that some folks are grossed out about yolks. So here's an egg, here's a clothed egg for you, okay? But 70% for future opioid remediation, that's the yolk, okay? Like everything else, the definition of opioid remediation, which includes, you know, reasonably related administrative expenses and reimbursement and the stuff for roads and stuff, all of that, consider that not the yolk. The yolk is 70% for future opioid remediation, exclamation point. Which means that, you know, the stuff that keeps me up at night, the possibility that these funds will be spent on, I don't know, like subsidies for tobacco farmers, as was the case in North Carolina for its big tobacco funds. You know, so the nightmare amounts, it's capped at 15% as well, okay? So, you know, this 15% cap, it is fair to say that it is kind of the clearest contractual protection against our big tobacco spending nightmares as we're probably going to get in 2022 dystopic America. And this 15% cap is actually subject to our documents only reporting requirements. We can, if anybody is curious about what rants I might have in store related to reporting requirements, why the settlement agreements don't have enough of them, please email me after. Happy to do that in a separate webinar. But just for our purposes, know that this is, you know, the gist of the translation of this is this for the states. States, if you can't even hit 70%, meaning if you can't even spend 70% of your funds on future opioid remediation, you have to confess your failures to the settlement authorities. Also, it'd be really nice if you publicly reported this, but it's not required. Okay, so that's how the language speaks about all of this. And these slides, I'm going to go ahead and send them to the NHRC afterwards, and you guys will have access to PDF versions of this. And this is the exact type of thing I should have mentioned at the outset for you furious note takers, of which I consider myself a part. So you guys don't have to do that anymore. But, you know, moving on to accessing these funds for harm reduction programs, because this is really the heart of why we're here, right? The stuff we talked about, all really important level setting stuff, and the citations are going to be good for you guys to have when you need them, if you need them. Moving on to the stuff that kind of, you know, makes my morning every day when I hear success stories, right? We're going to kick it off with, you know, the lay of the land related to expenditures. Rules related to what states can spend these monies on. We're going to be talking about that now. Importantly, is a document called Exhibit E, okay? Exhibit E, and we'll flip through Exhibit E together after this. Exhibit E is called the list of opioid remediation uses, okay? It's a 15-page list that sits at the end of the settlement documents for the two biggest opioid settlements. The $26 billion thing I mentioned with McKesson, AmerisourceBergen, and Cardinal Health and Johnson & Johnson. But it's also attached to Purdue materials as well, specifically Purdue's National Opioid Abatement Trust distribution procedure documents, which are the documents that speak to how states and localities can spend their funds, okay? So Exhibit E is important. It's attached to the two biggest settlements, and together they, I think, I'm gonna pencil that out, probably, I don't know, like 32 of the $36 billion on the table, Exhibit E is attached to that, okay? So it's important, it looks like this. If you guys want to follow along the Distrib Docs link, E1, it sits at the appendix, it's at the very end, you can follow along and find E1 as a page number. Importantly, the settlement agreements refer to Exhibit E as a non-exhaustive list of expenditures, okay? So it's a menu of expenditures, but states can go further, or frankly, they can sink beneath it, as we're going to see here in a bit. But just so you know, I should provide some background. Roxanne Saucier of the Open Society Foundations and I are working on an analysis of Exhibit E to assess. Initially, it started out as a project to assess how promising from a progressive harm reduction standpoint some of these lists were, and how worrisome or punitive we thought some of these lists were, because as we can all expect, some states are going to be spending these monies to, really at least try to say that they have fully adopted the public health response to drug use. And then other states are going to slip into what I call the carceral state mentality, where their expenditures will just backslide into things that inevitably uphold the carceral state. So there's a progressive and punitive kind of two ends of the spectrum. And there is an analysis being done of states' expenditures and to kind of see where things are headed. That's this project separate and that's separate and apart from this presentation. So if you're interested, please reach out to me. But for now, from that separate assignment, some gems, some pearls of wisdom I'm going to deliver to you guys here today. About half of the states reference or incorporate Exhibit E to express their expenditures. Okay, so it's about half the states don't have their own lists. They're just saying, yeah, in terms of what we're going to spend it on, Exhibit E is going to control. As long as localities stick to Exhibit E, we're fine. So about half the states are taking that approach. Just over 20 states have, they acknowledge Exhibit E because they have to as part of the national, the national and global settlement agreement documents. But about over 20 states have published additional lists as well that spin off of Exhibit E. So like Exhibit E remixes. Okay, so just over 20 states have released their hot new Exhibit E remix tracks, and some of them are really good and some of them are really bad. And the remaining states are TBD, so we don't know if, they haven't spoken to expenditures at all, and we're to assume that they're going to follow Exhibit E, but we want to give them space to kind of do more and say more in the interim. So I mentioned that, over 20 states have published these remixes of Exhibit E, these spin-off lists, right? What do these lists look like? There's a massive range of harm redux friendliness. States that express additional spending priorities beyond simply mentioning Exhibit E, which is to say, so the states that do more than just say, yeah, refer to Exhibit E, they go above and beyond that, and they do the extra work, and either their legislature or an advisory committee or whatever, some official group comes out with an additional list of what these things can be spent on. Those lists either treat Exhibit E as a floor or a ceiling. So they either look at Exhibit E and either consciously or unconsciously go, all right, yeah, Exhibit E, that's saying everything. So it's saying nothing. This is so basically it's lawful evil, right, in the RPG matrix of things. So we're going to go ahead and go further. We're going to go more progressive than Exhibit E. Some states are doing that, whereas other states are looking at Exhibit E and they're like, what? Not all of this can go to law enforcement. We clearly have to find some way to make this go to law enforcement. So some other states are treating it that way. And those, are exaggerated ends of the spectrum, but the spectrum absolutely exists. And to pull from two examples, by the way, before I pull up specific incendiary text, to the extent that folks will assume that any state that has published an additional list is doing a good job, that just isn't the case. Take a look at Montana, right? When they speak to expenditures, they don't really say much, but this is their most detailed section, and it's law enforcement exclusive. And compare that to what's coming out of Massachusetts, which the full range of harm reduction says it all. And this is an indicative snippet of the rest of the plan. So this is why it's really worth it to dive into states' plans, specific, as a state by state specific exercise. Take a look at your state's plan. And if you're ever told by your state's AG, or if you're in a meeting and folks are telling you, well, we're the only state to do this, we're the only state doing this, no other states are doing that, I'm going to preempt some of those types of excuses towards the end of my presentation. But if I don't cover some of the excuses you guys are getting, let me know. And, ideally I can provide citations within the next day. So just to say that we've done it, right? Because it's a 15-page document. It sits at the end of like a 300-page PDF. I completely understand if looking that up is not considered fun for a lot of people. So we're just, to say that we looked through it together, we're going to flip through it very quickly. Before we flip through these 15 pages, it's worth it to note that states and localities, they must give priority to Schedule A's core strategies. This is a 3-page kind of truncated list. And states and localities may pick from Schedule B's approved uses, which is 12 pages. It's a lot longer. Just so you guys can recognize it on site, right? So if you see it floating around, you say, oh yeah, that's Exhibit E, because I've seen it before. We're just gonna flip through it. So this is a first page, Exhibit E. Remember, this is core strategies, right? Stuff that states and localities must give priority to. Now, Schedule B is the full menu. This isn't assigned a specific priority list, but it's worth it to note that it's broken out into 2 parts. 3 parts. Part 1 is treatment. Treat OUD, support people in treatment and recovery. Connections care, access to needs, address the needs of criminal justice involved persons, pregnant or parenting women. Part 2 is prevention. Prevention specific. There's that prevent overdose deaths and other harms. Harm reduction section, you guys can read that and judge for yourselves. And part 3 is other strategies like the potpourri. The most interesting thing in other strategies is a provision for dashboards to display public expenditures. So that is actually a legitimate use of funds if states want to publicly report how they're spending their monies, which I'm biased. I think that's a good use of spend because, typically sunlight does disinfect. Oh yeah, that's the last page of Exhibit E. All right, so we flipped through that together. I mentioned at the outset that I'm really trying to position myself as the unofficial consigliere to harm reduction activists nationwide, trying to use these monies to move the needle in harm reduction in my lane. So I can't, come into this presentation like an MD and tell you what to fund over other things. But from my lane, these are the things that I think are most useful for you guys to know. So we can all think of examples where the letter of the law sounded great, but the spirit of its application produced something terrible, okay? And vice versa. And I'm mentioning this because we've talked a lot about these lists, but it's worth it to zoom out and just note that this is all a predictive exercise. We're in this odd interim period where states are receiving their monies kind of as we speak. The states with that have managed to get all their subdivisions to sign on to agreements as well. States are receiving their monies, but they're not really spending it in earnest. This is a really weird interim period for activism and also journalists. I've gotten a lot of journalists reaching out to me about attorney's fees, which is what they do when they're bored and they can't think of, there isn't anything more pressing to talk about. We are in this weird interim period where all of us, like sportscasters, we're like nervously wringing our hands before this sports event has actually started. States have not begun spending their monies in earnest. Some states have, but 2022 is considered year 1 of an 18-year payment term, okay? This is a marathon, not a sprint. And these lists, some of them do sound bad. Some of them do sound awesome. But to the extent that this is a marathon, not a sprint, I would think about like pacing out your fury and your energies for the long haul, right? And not put all of your energies into the predictive exercise of trying to judge at the outset whether or not a state is going to utterly fail or utterly succeed. The things that are important to know, though, for now, is that if they do fail, there are protections. And this is where I put on my consigliere hat, okay? There's a section 6D. It's called State Subdivision Enforcement. The summary of this, so the citations are here. The summary of the section is that a state can go after its localities, and the localities can also go after the state if monies intended for future opioid remediation are not used on things that kind of look like Exhibit E. Okay. Do we have these enforcement rights? Each of us in this room? Absolutely not. The enforcement rights belong to the parties to this agreement. So this is something you would have to bring up to like a city council or things like that, or an advisory committee with the AG present. That's a type of thing to do. But there is, there is a mechanism built into the agreements for the situation that may or may not occur, hopefully does not, where a state just utterly fails to heed Exhibit E in its entirety. Now, for the second part of this accessing harm reduction section, I want to talk about who to hound and how to figure out who to hound just in general. And if you're bird dogging, who to bird dog, right? So I broke these things out into steps, and I'm going to go through the steps and then we'll go through a couple examples, okay? First, this is a plug for my own spreadsheet. You want to use states' opioid settlement allocation plans to see where most of the funds sit, right? Again, that spreadsheet is available here at this URL. You want to check the control notes, which is my third column, and controlling documents to see if I've already given you the answer, right? Like which entity controls the majority of funds. I might have already put that up there. If it isn't there, you want to trawl your state's dedicated opioid settlement page. I'll link to those in a bit. And Attorney General press releases for clues. And lather, rinse, repeat as needed. I'm an elder millennial, so naturally I think of Phoebe. I do know that Friends is coming back though, so Gen Z, this is for you as well. These are the steps that I do. These are my steps. Okay, so I'm not like repurposing these for a separate audience. This is what I do. I literally check my own spreadsheet to check on the things that I've written down and have forgotten. Just a little bit about the resource itself that I'm talking about, right? Control notes, what are we talking about? I'm talking about this. This is a spreadsheet that sits on settlement spending. And this spreadsheet, it's important because it actually breaks out column by column percentages of a state's entitled slice of its settlements that it gets to keep for itself, the percentage it has to give to a special fund if it has set one up, and percentages it has to give to the localities. So for each state's plan, I've broken out how it describes its own allocation, okay? So if anybody ever tells you, oh, we're the only state to pursue this allocation, you can literally check the spreadsheet and see if they're lying or see if they're just blustering, rather. An example, Kentucky's allocation statute divvies it up 50-50 between the state and local governments. Okay, so that's why these columns are so colorful, to distinguish the state portions from the fund portions from localities and the miscellaneous, right? Because Louisiana is giving 20% to sheriffs. Control notes. I refer to it as a third column. I guess it's the third major column, but in any case, the control notes, essentially as described, I do describe where I can, who controls the biggest chunk of funds. So, for instance, California here, you see 70% of it. It's housed in the fund created by this bill and appropriated by the legislature according to specific criteria listed in these subsections, okay? So I typically try to include who controls the biggest chunk of funds in the control notes. Sometimes that information isn't available though, or sometimes that information needs to be updated and I just haven't caught it, in which case, if you're out on the lam and I've left you hanging out to dry, these are the steps I want you guys to take, okay? We're gonna do two examples. One, I'm going to consider a semi-easy example in that it only really involves steps 1 to 2. It comes from Nebraska. Okay, so if you want to figure out who to hound, step number 1, use my spreadsheet to see where most of the funds will sit. Most of the funds, 85% of them, are going to sit in the fund created by the statutory trust or the bill to create the special fund. Step number 2, check control notes and controlling documents, right? So in the control notes, it kind of just give you guys the answer, right? It's that the committee, the advisory committee will go ahead and control 85% of these funds. And the fruit of this labor, if you go through this, if you go here, right? Nebraska Opioid Settlement Remediation Advisory Committee. I link to the committee's page, the working group site, where you can see their public meeting calendar and their meeting agenda. They'll post meeting minutes as well. So that's the fruit of all this labor. And that's like the closest I can get you. And the last mile is you, right? So the chaotic example, though, comes out of Kansas. It's somewhat chaotic in that usually it's not that usually states have the answer, and then so 80% of the time states have something there. That 20% though is kind of split 50-50. It's a state either just is totally mum, or a state like is TBD, and this is a TBD instance. Okay, and I'll show you why. So this involves steps 1 through 4. So for Kansas, who controls the biggest, or where will most of the funds sit in the special fund created by HB 2079? Check control notes and controlling documents. My control notes are scarce because that's what existed at the time. So you want to go to, it's check control notes and controlling documents. The control notes and the controlling documents are scarce because details were lacking at the time. So you want to go to step 3, trawl the state's opioid page. Click here. It doesn't link to state's just general page. If a state has a dedicated opioid settlement page, I try to link it. I use the state names to try to link them. So if you see a state and the name is hyperlinked, click on it. It might be a treasure trove of things you need, but didn't know that you needed until you clicked on it, right? So step 3, you want to check press releases as well. But from this opioid settlements page, right, that Kansas's dedicated opioid settlements page, you'll note that there's a note from the AG says that the advisory committee is currently being formed, right? So that is, you get confirmation that it is indeed TBD. And you want to lather, rinse, repeat as needed. So by doing that is where I went back to the Kansas Fights Addiction Act. And that's where I found a section 4D, which describes this provisional grant of power that allows the AG to periodically transfer monies from the statutory fund where the state's opioid settlement funds will sit to the Sunflower Foundation, which I've never heard of before, right? So it's just if you're reading through these things and you're just like, what? Okay, I'm going to write that down. That's me too, right? So I'm reading this. I've never heard of the Sunflower Foundation before, but it ends up being useful because they have a current grant opportunities portal, right? So that's the fruit of this labor. That's an incredibly useful thing to find, especially if you're a nonprofit organization. So, often this process will bear fruit. If it doesn't, it's typically because the state hasn't set up a grant portal or it hasn't set up its advisory committee yet. But if you just have a sinking feeling and you think that somebody's hiding the ball, email me. I might have heard something. As a last resort, step 5 really should be email me, okay? So to close things out, we're gonna finish it with probably my favorite section of all time in any of the PowerPoints I've made ever, how to avoid being hustled / use citations as receipts, okay? So I get a lot of emails from my colleagues who come out of meetings with their legislators or with their with policy directors for a certain, working policy director involved with a certain working group for the state, et cetera, et cetera. They come out of these meetings and they're like, okay, we were told that blank. Is that true? And sometimes, the excuses that my colleagues get are just kind of like, okay, I can see why they said it that way, but it's not helpful why they said it that way. And then other times I hear things where I'm just utterly and completely incensed. It's like they're literally depending on you not having read the agreements to tell you that. And I find that so deeply bothersome when that happens, because anybody who relies on the privilege of having the time to read through legal documents to bully others out of opportunities, that's the worst. I've designed my career around doing the exact opposite of that. So I have a vested interest in really making the law accessible as much as I can, especially when the capacity of opioid settlements. Okay, so that's the spirit driving this section. We're going to go through 3 of the excuses my colleagues encounter most. First, We can't change the MOU, which is the Memorandum of Understanding or the Memorandum of Agreement or the state subdivision agreement. We can't change our state's plan. Not true, okay? I want you to go to section 1, the definition VVV, provides that a state and its subdivisions, okay? So it's not just state, not just subdivisions, either can revise a state subdivision agreement if it just goes through the normal process of getting it approved in the first place, which if it was approved by the legislature in the first place, then go through that process. The translation is that there isn't a hard and fast deadline for when the settlement administrators will accept an amended plan, okay? So legally speaking, we're setting politics aside, which is a big set aside, but strictly according to the settlement agreements and strictly as a legal matter, the ball is still live. You can amend the plan. Whether or not there's a political momentum to do so is a separate question. But if you are told as a legal matter that it cannot be changed, that is false, period. Number 2. We're the only state giving this much money to X, right? So this goes to allocation, like that state local allocation stuff, like how much money will sit with the state, localities fund, et cetera. So often I'll have folks come back and say, listen, my AG told me this, and it's a situation where the state is blustering. They don't have the 50 state survey. They haven't checked my site. So in their perhaps good faith and goodwill, they genuinely think that they're the only state doing X, Y, or Z. Regardless of the intent behind the statement, you can figure out whether or not it's true or false with this information, okay? So I'm gonna break down really interesting statistics related to allocation. States that are placing 50% or more of their entitled settlement funds, so that's $26 billion pie, a state's entitled slice of that pie. States that are putting 50% or more into special fund or nonprofit, in I think Ohio's case, 17% of states. And most of them, 12 of the 17, are placing 70% or more in the fund, which speaks to some of the default allocation mechanisms, but that's a separate topic. States with a roughly 50-50 split of control between the state government and localities, 15. States giving 50% or more of the control to localities, 11. States reserving control, 70% or more for themselves, 5. And the TBD states are 2. There's a pie chart, it's colorful pie chart for you guys. This is what it looks like visually, okay? So to the extent that your state is saying, we're the only state giving this much money to the localities, or we're the only state that isn't keeping all of its monies for itself. I mean, it's not true or true based off of the data that's on here. And if you guys want the specific state counts and to see where your state sits, go ahead and check out the allocation plan spreadsheet, or just email me if you have any follow-up questions after having looked at this information. But I just really resent when my colleagues are bullied using disinformation. So I just feel free to screenshot this. Again, these slides will be sent out as a PDF after this presentation, but screenshot this and circulate it as you will, because yeah, states ought not be blustering folks into a corner, so to speak. And excuse number 3, we can't fund harm reduction expenditures because we don't have the infrastructure for it. Well, then why not build it, right? Because the 2 examples I could think off the top of my head, March 2022, Wisconsin's governor signed bipartisan legislation to decriminalize fentanyl test strips, right? Used to be drug paraphernalia, as is the case in many, many states still. In July, so this month, like earlier this month, California's bill passed the Assembly, passed the Senate, now passed the Assembly, is en route to the governor. Decriminalize safe conception sites. DPA, I know has been at the forefront of that. Present day updates from the audience, please, because we are in the room full of experts who can talk to this very thing. The patchwork of Good Samaritan laws, or this is outdated. This is from a 2019 DPA publication, but we can all speak to the patchwork of enabling legislation that may or may not exist, right? We can all speak to the capacities of our states, like, can they do these things? Is there the political momentum? But the power of us all getting together is that we can crowdsource case studies to either, like, bolster our own cases in our own states, or like rebuff excuses that are thrown our way. This is absolutely, this is a tremendously good use of our time. Using opioid settlement funds to maximize the public health response to drug use is the official goal, right? But if we're going to speak, unofficially, if we're going to do the real talk version of it, hundreds of thousands of people had to die from a public health crisis, exacerbated arguably by failures in federal regulatory agencies, who could have done, and which is to say nothing of Congress, which could have done a better job at the outset. So now states and localities, using parens patriae doctrine and their various standing rights as sovereigns, have to sue private pharmaceutical companies for financial transfer back to governments to save future lives, but to not recompense the moms who have lost their sons because only Purdue is doing that. We really, as much as we can use these funds, the only way to not make this a sham, frankly, in my mind, is to use these funds to bend the arc of humanity towards justice. And I absolutely believe that we can do that, because the cynicism that I felt when I started this project and how I feel now, night and day. I'm not going to say that I feel, it's in certain circles, it's blasphemy to say that you're optimistic, right? The fight continues. Absolutely. But we do have clear contractual protections against the big tobacco nightmare from happening, and the rest of it is up to us. And I would love to hear from all of you, but thank you so much for letting me monopolize what looks like an hour of your guys' time. I'm going to open up to Q&A now.
Christine, thank you so much. 120% exceeded even my expectations, and I know that you're a fantastic presenter and have fantastic information to present. And we have questions in the Q&A. We had a few people put questions in the chat as well.
I will say that as a general matter, how the monies actually reach the folks doing God's work on the ground is a state by state question. And that's a shitty answer, because it doesn't answer. It's not an answer to your question, excuse my French, but it really is a state by state question, right? So you would have to look at your state to see where the money sits, and then when it sits there, how it trickles down after that. I will say that as far as grants go, it is the consensus amongst my colleagues is that proper abatement cannot happen without the involvement of nonprofit organizations, right? So the money does have to reach folks like us, like those in the room, somehow. How it reaches is a state by state question, and a state doesn't have to do a grant program. But I can tell you what is happening in the majority of instances. In the majority of instances, if a localities in receipt of funds will then give their funds to the nonprofit organizations. The states will use their funds for big infrastructure projects, maybe hire outside agencies to do something, I don't know, but it's really like the local portions that'll hit the OTPs and the folks who are actually need the harm reduction funding for the event next week where they're going to be doing X, Y, and Z. That money is distributed by formula typically. And when it, formulaically, so the money that's set aside for localities divvied up to the various cities and counties by formula, okay? Which formula they're using is also a state by state question these days, at least. But once it reaches your city or county, it's really like the majority of the time, it's going to be by straight city council appropriations. That's the majority of the case, the majority of the cases I've seen. In the minority of cases, it's this situation where they already have a grant portal set up, or they're planning to do, the localities are planning to do a grant application process. If you see a grant application process, is typically going to come from the state. If you want to hound your local government for funds, I would go straight to the city or county meetings that are set up to discuss opioid related issues. And if those meetings aren't public, and your state has public meeting laws, then I would ask that you reach out to me, because this is something I'm also working on the side as well, because this is, you can tell that I have a whole slate of side projects that each relate to specific things that piss me off. Adrian, I'm so sorry if I did not answer your question specifically enough, but typically the money will come from the localities, and it'll be distributed by formula. And whether or not that's already happened in your case is a state by state, locality by locality question. Email me and maybe we can do some investigative work together that's jurisdiction specific. Sure. That's a great question. And really, if we're going to sit back and like, light a joint and consider it as deeply philosophical too, but as it relates to the settlement agreement specifically, future is just not reimbursement and not administrative expenses. So, which is to say, as long as it's not past, it's future, which means that present expenditures are future. Present is considered future. So if it's like, as long as it's not like billed or labeled as a line item or appropriated as a form of reimbursement, and as long as it can't be considered an administrative expense, it's considered future opioid remediation. So not past, not admin. So present OR goes to future opioid remediation as well. What an important question. Okay, so that's the golden question. Okay, how states will actually be spending these monies, because if you take a look at Exhibit E, and I'm sure that there are tons of folks who agree with me. If you just pull anything out of Exhibit E, it can in its application can be harmful or helpful, frankly. Like the actual interventions, depending on who's doing it and how, it's like PDMPs. All right, great, I guess, but is it entirely law enforcement controlled? Because that does make a difference, right? Because if there's data controlled by public health agency or data controlled by law enforcement, we all know the differences. Are there any protections in place to ensure that it's spent on evidence-based treatment though? I mean, the only legal protection that I could think about that's built into the agreements is the reporting requirements thing related to Exhibit E. Let me work backwards and explain that. So Exhibit E is described as a collection of evidence-based things. And they kind of just stop there. They don't really go into, all right, so it's based in evidence, but is it good evidence, or is it like evidence that, is this what we want going into the future? Like it as a policy, it excludes a policy consideration. So I think what you're talking about is both, will these monies be spent? You're concerned about whether or not these monies will be spent on evidence-based things, but then also just as a policy measure, like, will it be spent on the right evidence-based things? There are contractual protections in place for spending on evidence-based things, in that if a state doesn't spend its future opioid remediation amounts on things that look like Exhibit E, which is explicitly defined as a list of evidence-based interventions, then yes, there are consequences for that. But I want to separate that from what you're describing, which is, are they going to be picking the right evidence-based ones? And the answer to that is no. There are no contractual protections to ensure that states are selecting the normatively correct, or even the morally, philosophically, whatever. It could be the clearly correct answer. We're just not even going to talk about Roe. It's like, it could be the clearly correct answer, but we could not choose it. And that, are there protections against that happening? No, there aren't, unfortunately. Simply any future activities. Yeah. And I'm absolutely not an expert in the situation you're analogizing to, but I do know a little bit about it. It's simply any future activities, which to the question related to Rachel's question earlier is present. So it doesn't have to be like new fancy things. There are okay, so that's as a general matter. Sidebar, there are some states, Massachusetts is a good example, where they include notes about supplantation. Okay, so, oh, got a message from Army. Oh, sorry. Thank you, Army. So there are terms, there are provisions in certain states' plans that speak to supplantation, right? So it's like the monies, so it usually reads some, I'm paraphrasing here, it obviously sounds better than what I'm about to say, but the gist of the provision says something like, opioid settlement dollars cannot be used to supplant existing federal or grant funding for these existing programs in place, right? So if a state is already doing a bunch of things and it's already funded and these programs are already up and running, opioid settlement dollars for the states that have these supplantation provisions can't come in and replace that funding. It has to supplement it instead, right? So there are in certain states, I'm bungling this. Let me like start over. In certain states, what you're describing, is treated differently. In certain states, there is a restriction against using these settlement dollars to replace funding that does exist. In certain states, these monies do have to go towards expansion specifically, and it can't go in and replace the monies that the state was already giving to the localities for a particular program. And in other states, they don't have that protection against supplantation. Supplantation is another thing that gets me a little upset. So if you're interested in being involved in another side project I have, please email me. But this is these are one of the ways that the bureaucracy can provides these little cracks for funds that could otherwise be spent on useful things, kind of disappears between line items, right? Because if a state has, like, let's say a locality has like X number of dollars set aside for this program, and then 80% of it comes from the state, and then it gets these opioid settlement dollars, it has the choice, if there's an anti-supplantation provision in place, those additional settlement dollars have to go towards expansion, right? But without those anti-supplantation provisions, or without any other additional protections, other protections against this can come from different areas. Those monies, like, theoretically can go to a slush fund, right? So a state can say, yeah, we're just gonna like, if that 70% future opioid remediation thing didn't exist, these monies, like all these settlement monies, can technically go into a slush fund. That's kind of what happened with the big tobacco situation, right? It's like, we're going to consider everything reimbursement, or we're not even going to consider reimbursement at all, because there is nothing in the master settlement agreement that contractually, like, there were no contractual mandates for intent on spend. It's a more accurate way to put it. So this too is a state by state question, and it relates to supplantation. And I just kind of spun off into like a rant about supplantation. Sorry, Philomena, but if, again, email me if you have follow-up questions. Yeah, they have to report it to the settlement authorities that that they technically have to do that. The consequences for reporting and then not like fixing the problem. Okay, so there is a grace period for like, okay, like you can go ahead and like put back the funds that you misspent, or you can try to fix the situation. There's a grace period for trying to fix it. If a state just doesn't care and just doesn't hit that 70% at all, the localities can actually make sure that the state doesn't get continued funding, or like the localities can ensure that the settlement administrators don't continue to give the states money just so it can be misspent. I explained that poorly just because it's like the heater is on. I'm kind of getting flustered as I'm answering these Q&A questions, and But yeah, the consequences for doing that, state can, the political subdivisions can tell on the state, and the settlement administrators can decide. It's up to their discretion, but they can decide to not, they can decide to put a hold on states' funds. It's probably the more accurate outcome, because it's not like these settlement administrators are, deeply incentivized to penalize states for not spending monies on, for spending monies on drug courts or something. Oh, I saw a comment.
I
Okay.
saw that Allison, Christine, excuse me, Allison asked kind of a follow-up question down a little further. What happens if localities challenge section 6, which I presume is the section that allows for a challenge to the way the monies are being spent?
Yeah, section 6 goes into that in more detail. So there, I would recommend just reading that in general. But it's one thing I will mention about localities, and it was on the slide as well. Localities can only challenge if their state subdivision agreement allows for it. Okay. I want to point you guys to Arizona's memorandum of understanding. Arizona's MOU stuck out to me early on in the game because it had these enforcement rights built into them, and they were very toothy. That the regions can go after the state, and the state can also go after the region. Arizona is a state that in its MOU has given localities enforcement rights to go after the state. Like, so the state government's like, hey, regions, if we mess up, we're going to give you the power to come after us if we're not doing our job. Arizona's MOU is an example where that does exist. So you can kind of see the consequences, how they play out in Arizona's MOU in a practical sense. So I recommend that you read that. But the nuances and details of enforcement rights are further explained in section 6. But it is enforcement with teeth, and that the settlement administrators can opt to put a hold on states' funds if there is egregious misspending. Yeah, so it's everything, right? So it's not that it applies to the state's whole entitled slice, which is not just the portion that the state government keeps for itself. So if the state is getting like $300 million and it's splitting it 50-50 between localities, the state portion, the state share is $150. The locality share is $150 or 150 million, and localities is 150 million. But the state share is considered separate as a legal term from the state's portion of funds, or the state's, this is why I keep using the pie example to differentiate it from like a state government's allocated share. A state's entitled slice of that $26 billion pie. So all of the settlement monies that are going to the state as the jurisdiction, not the state government, that 1570 thing applies. It does not apply to municipal funds. Well, I guess that thing applies to like the state share as a whole versus like the state's portions of funds as a whole versus the state government's individual share or the locality's individual share. Hopefully that made sense.
So Christine, if the state allocated some funds to the cities, and then the cities were like, great, we're going to use half of it for, our new parking garage, do they have to report back that they're using all of it for opioid remediation? Like if the state has already used its chunk for admin?
Yeah,
I'm guessing there's not an answer.
there is somewhat of an answer. Actually, so I don't know if I can screen share very quickly and go back to a slide, because that actually might be
and FYI, our participants can't see the questions in the Q&A that you and I can see. So that's why Harmony's repasting them in the chat.
Oh, thank you, Harmony. Right. Okay, so let me go ahead and I'm going to try to find. Here we are. So here, if that 70% future opioid remediation threshold is met, the monies can be allocated, however, between the state government, the local government, and the fund. What you're asking is, a state's, or a locality gets a certain pot of money and decides to spend half of it on nightmare things that have nothing to do with the opioid crisis, do they have to report it? And the question is, it depends. But the reason why it depends is because of this very thing, right? Here, it's probably best to do it this way too. 15% of funds overall headed a state's direction can be spent on nightmare things. But where, like, who's able to do that nightmare spending is a state by state question. To explain it a different way, this, wait, where am I going? There we go. Okay. This requirement that the monies, 70% of them be spent on future opioid remediation. A state can just keep a little bit for itself and give the majority of the funds to localities and say, hey, localities, you do all the heavy lifting with abatement. We're going to spend our tiny little 15% slice on nightmare stuff because we can. We're not even going to be involved with abatement related things. Localities, you do all the heavy lifting. In that case, then, married to your example, the city in receipt of monies would have to report it because they would be under a directive by the state. It's like, we are assigning you, locality, whatever, to spend all of your funds on abatement because we, the state, have decided to not do that and make you do that instead. We've decided to make the localities hit the 70% future opioid remediation threshold instead. So, and this is why, like, you'll see sometimes traditionally, conservative states giving a bunch of money to the localities, and you look at it, it's just like, whoa, like, did the political tides change? Like, what happened? But really, it's actually what their dog whistling is. All right, localities, we're going to task them to do the majority of the abatement spending, and we get to keep the admin expenses and the reimbursement stuff and the 15% for any governmental purpose stuff for ourselves. So there's the allocation of funds, then there's the allocation of who controls the funds, which is not necessarily, lined up exactly with the allocation of funds, separate matter. And then there's the allocation of heavy lifting, right? So in the example where a state has told the localities, you have to do all of it, you have to spend all of your monies on abatement, they would have to report. Yeah, I am able to do that actually, because I was doing this yesterday. This is like hot off the press. Okay. So here we go. All right. So again, this is an entirely predictive exercise. We are nervously trying to anticipate how states are going to spend their funds. There is a chance that a state with a terrible sounding list can do an amazing job with abatement, and vice versa, right? But I want to point out Maryland for a second. There's a HB 1274 is the bill that creates their special fund. Within it, they describe what the monies can be spent on. There is a line item for everything kind of sounds bland, right? That sounds offensive, right? To say that an expenditure list sounds bland, because all of it is exciting, because all of it should be designed to save lives. But some of the stuff is more run-of-the-mill. After you read a number of lists, some of the stuff gets more run-of-the-mill than others, right? A lot of this is straight from Exhibit E and a little run-of-the-mill. The stuff that jumps out to me, though, is item 4. I'm going to read it to you. Expanding the heroin coordinator program, including for administrative expenses. So I'm like, okay, like, what's the heroin coordinator program? I Google that. I learned that it's a multi-agency partnership of law enforcement and investigative strategies combining together in this coalition to do DEA stuff. Basically, some of these states' lists read like a wish list for states' mini DEAs. Other lists read like they've been written by somebody who's been hounded by a bunch of harm reduction activists nonstop, and we love it, right? So Maryland is a situation where it's like, ooh, like, wow, like, if I didn't Google that program, I would have thought their list was boring. I mentioned Montana's list as law enforcement heavy, kind of a similar situation where they don't go hard on anything. They're not excited. None of their expenditures are particularly exciting, except when it comes to law enforcement, and then they go super extreme. Lists that are really good right off the bat. I mentioned Massachusetts. It just has really like language that makes me sleep better at night in there. Colorado, no list is perfect, and Colorado's isn't perfect, but I really, some of the stuff that's coming out of Colorado, Jose Escobar out of Colorado. Jose, if you're in the webinar, hello. Great people in Colorado, great people everywhere, but Colorado kind of came out like pretty heavy at the outset. And I was involved, I've been watching them for a while as well. And Colorado's list is pretty cool too. So that's, hot take for me. There's the companies corporations will adjust, right? So now they're going heavy into recovery sciences, right? So one public health academic describes Purdue's renewed involvement now in the recovery space, trying to abate the crisis. It's like poisoning the well and then establishing a monopoly on the very monies that are on the very medicine that'll cure the village of dysentery, or something like that. It's a very cynical kind of situation where you contributed to creating the problem and now you're so focused on trying to come out as a good guy from this hell that you've created. So I have seen, this is me answering a question in a roundabout way, I have seen the bad corporate actors try to behave in a little bit more of a corporate woke way, which is, I guess, adorable if it wasn't so disappointing because it's so belated. I will say now that I'm getting, maybe this doesn't answer your question, but I'm getting quite a bit of commercial requests from pharmaceutical companies who are interested in latching on to states' opioid settlement dollars as a form of startup funding, right? Which I went to Stanford for undergrad. I did PR for Google. I've worked for a startup in Austin. I'm a little bit familiar with the delta that exists typically between the way a tech product is marketed and where the engineering sits at the time. I'm also thinking of Theranos and Elizabeth Holmes. And as a Stanford girl, I'm like, come on, like no fraud, please. But I have seen, and these are not the companies that are being sued, right? So I'm talking about a different set of companies, but like Pear Therapeutics, for instance, has spent, quite a bit of money on policy and academic detailing. I've seen them show up in meeting agendas, doing presentations for like Kentucky. I know that North Carolina has a recent bill that would give $150,000 to Pear Therapeutics for a freaking pilot program, like going after venture capitalists for money for your pilot program is one thing. Tapping into funds that are intended to be spent to abate a crisis for a form of software that may or may not work is deeply troublesome to me. So I have seen corporations as a whole adjust. The way they're adjusting, though, I generally find annoying. Is my short answer. Yeah, so, in the harm reduction community, we were recently very excited, and I say recently now, but it's not very recently. Biden came out, with some pretty, finally, like from the highest levels of office, harm reduction is acknowledged as a sensible thing to do. And we thought, yay, like this is really great. Can they go further? Absolutely. There needs to be also a tremendous amount, a lot more clarity around how opioid settlements interact with Medicaid reimbursements, because that is a tremendously like hairy area that I think a lot of people get tripped up by. So in addition to funding more of the right things and pushing harder in the harm reduction realm of interventions, I think that there needs to be a tremendous revision in the way the federal government like talks about what it's doing. And I think that there needs to be some acknowledgement of the fact that opioid settlements do exist, because as it stands now, the world of federal grants and federal funding and opioid settlements, there's this like division between the two. It's like, and the folks don't interact very much, and there's very little understanding in between. So I do think that there needs to be, quite a bit more effort to give people a sense of a holistic sense of where monies will be coming from. And, that's topic for future office hours. I'm there. I'm looking at the time. I want to hand it
I
off
know.
back to Mary.
This has been so fantastic, and I want to wrap up, Christine, by thanking you. Jonathan had one more question about areas of opioid settlements funds that will be better than others, but I think the answer I most commonly heard from you was, well, state by state. And I think if you want to keep an eye on the states, we all certainly know where to find the information. That's at the opioidsettlementtracker.com. Wow, I've gotten more positive feedback during this from staff and other people who are engaged and participants than any webinar I've ever been a part of. So I'm not surprised. You all take her invitation seriously. Christine will email you back if you email her. I was on a similar webinar with just some policy people like this, where she presented about 2 months ago, and that's what resulted in this. So this is her brainchild, this is her passion. And I think she'd be willing to dig into the details of state plans and give you individual advice going forward. But with that, I'm going to let everyone move on with their days. Thank you, Christine. Thank you so much. And this will be available. We'll send out a link to the recording for folks and their colleagues to the list of attendees. Thanks, Christine.
Thank you so much, guys. It was such a pleasure, and absolutely take me seriously when I say please reach out with any questions. I would love to hear from any of you.
Thanks so much. Bye-bye, everyone.